My name is Rock Palermo. I'm an attorney in Lake Charles, Louisiana, firm of Varian, Bice, Palermo, and Wilson. We do primarily environmental litigation against all companies. We sue all companies for historical oil and gas exploitation, if you will, of the land. So we try and get the soil and the water cleaned up and all companies to pay for it. Today, we're talking about pushing environmental agendas in the age of Trump. We have an all-star panel with us, and if you'd like, if you hadn't signed in, go ahead and take a seat, and what we'll do is we'll sign in when you leave. That way we can kind of get started. As far as our panel, Richard Webster, the legal director for Riverkeeper, formerly staff attorney for the Environmental Enforcement Project at Public Justice. He's the legal director for the Eastern Environmental Law Clinic, also known as the Rutgers Environmental Law Clinic. He was an attorney with the environmental group at Arnold and Porter in New York. He pioneered the use of litigation regarding coal ash and fracking to both clean up water and reduce climate change impacts. Before becoming an attorney, Richard was a hydrologist and environmental scientist. He got his JD at Columbia and was articles editor of the Columbia Journal of Environmental Law. Next we have Pat Parenteau, close enough there, faculty at, and senior fellow at NELC, senior counsel, Institute for Energy and the Environment. He is U.S.-Asia Partnerships for Environmental Law Administration and New Economy Law Center. Got his LLM in Environmental Law at George Washington University and his JD at a great Catholic college basketball place, Creighton University in Omaha.
Go Blue, Jason.
We also have Kevin Thompson, who's an environmental lawyer, entrepreneur, and inventor who's been involved in high-stakes litigation across the country for more than 20 years. As a litigator, he's managed evidence in tobacco cases, patent cases, and environmental cases worth billions of dollars. And he's continually developed innovative technologies designed to organize and present evidence. Not only is he's a litigation consultant in cases like that, but he also is an adjunct professor of advocacy at LSU Law School and ANITA faculty member. He received a JD at Tulane after obtaining a degree in broadcast journalism from Marshall University. So that's our panel, and they'll each come up in a minute and spend about 20 minutes with you and field questions. It'll be, Q&A. You can play like you're the circuit court judges and throw questions at them as you wish. If I see it's kind of taking up time, I'll try and move it along. But as many of you know, when you watched Donald Trump's inauguration, you also watched websites get pulled down from the U.S. Geological Society, from NASA, from the Department of Interior. All during the Obama administration had been talking about things like climate change, like Arctic ice melts, like the fracking industry. Once the inauguration was done, those websites were gone. The social media accounts of those federal agencies shifted. And like I said, in Obama administration, those agencies would keep track of and do social interaction on things environmentally sound. We did have some issues during Obama. We had the Flint water crisis, so it wasn't a perfect time. But the Trump administration set out rolling back those Obama gains on global temperature issues, climate change, and Trump signed an executive order revoking and rescinding all Obama-era orders and reports addressing clean energy and climate change. He also ordered the EPA to review and revoke the Clean Power Plan, which required states to cut greenhouse gases from power plants. Trump directed Interior Secretary Ryan Zinke to review his agency rules, including one guiding hydraulic fracturing on federal and Indian lands. Zinke himself followed up with more orders of his own. One overturned a moratorium on new coal leases on federal lands. Another directed an agency-wide review of all existing regulations, documents, and policies that might hinder energy development. And as New Mexicans know, at the behest of Utah Senator Orrin Hatch, Trump ordered Zinke to review millions of acres of national monuments, including 2 in New Mexico. This all happened in the first 100 days of the Trump administration. You know, we protect our right to bear arms, we protect our freedom of religion, we protect our property rights. Those are all better protected than our right to clean water and energy. Out front there's a table on the Green Amendments. Pennsylvania and Montana have them. They say that clean water, clean air is fundamental and an inherent right. Democratic Congressman Cory Booker said that civil rights has to include the right to breathe our air and even plant tomatoes in our soil. There's a bill in Congress to allow suits under the Civil Rights Act for pollution. He said if our children don't have access to clean water and clean air, all the ideals we preach in this country are a lie. So today we're going to talk about the things that this Trump, we talked about it before a lot of you came in here, about the Trump voters, how there's a mindset and they're tough. It's a different orbit altogether. And Kevin's going to talk about juries with Trump. But first, Richard's going to come up and as Riverkeeper has done a lot of work in the Northeast, particularly in New York, and tell us what he's been doing, what he sees out in the fight. Richard.
Thanks, Rob. So, yeah, you know, I'm from Riverkeeper. Our job is to preserve the Hudson River and New York City's drinking water, and so obviously we operate in a very different environment to here. But I think that the fundamental principles are quite similar, and actually I've also done a lot of work in red states in my prior job at Public Justice. So the idea is to try to extract some thoughts about how we can move forward. And we're not coming to this panel saying there's an easy path forward. We're not even coming to this panel saying that we can win that often. But we are coming to this panel, I think, saying that we can't throw in the towel, that we have to really redouble our efforts to find our opportunities to make differences in how the environment is perceived by the populace, as well as legal hooks to figure out how to change things immediately. Because I think that big picture, the environmental movement was once a popular movement and then became kind of an intellectual movement or a law-focused movement. And I think, you know, what we see is that now is the time where we have to get back to the grassroots and really try to think about how to energize the grassroots around the environmental agenda. Because if we don't, then, you know, we're not going to win overall. We're just going to fight defense. So, first thing I've identified, just from our work, and this is, you know, I'm a hydrologist who's went to the dark side and became a lawyer. So I don't know anything about sociology, but I can just observe from what we're doing that these are the things that we're doing that are actually making a difference. So people power combined with name and shame. So trying to mobilize people to actually get out to meetings, shout at elected officials, complain about stuff, you know, and really get people to focus on the issues that they care about. And, you know, people talk about Trump voters. I actually did some cases in Pennsylvania with Trump, in Trump country. And even if you're a Trump voter, you care about the value of your house. You care about the safety of your kids. You know, you care about clean water. But I think that somewhere along the line, there's not a connection between those issues that people care about and the top level. And people seem to think, well, it's so distant from me, it's not going to affect me. And I think that's where our job comes in, to try to find organizing points where we say, no, it really does affect you. This is an issue for you, and you can make a difference on this issue. And I think if we can find some entry points, and I'll talk about a couple of entry points that we found, if we find some entry points, I think we start to get the useful dialogue going. Obviously, this is the old-fashioned system. Detailed comments from agencies containing science and logic, right? I think science and logic isn't particularly prevalent right now, but I think agency staff, you know, the government, agency staff are still the same staff they were before. But if you take away the top layer of appointees, There's still a whole layer of agency staff down there. Most of them actually, I think, are actually more motivated to do the right thing now than they were before. They're looking for opportunities to deliver decent decisions. But they have to find those opportunities in the face of normally supervisory skepticism, shall we say. And so, if they get good comments and they can say to the boss, look, if we don't go with this, we're in danger of getting overturned on appeal, whatever, then it gives them a lot more ammo than if it's just kind of a lot of angry, like, we don't like Trump, so screw you, right? State legislation, some places that's a possibility, right? What we're seeing, I think, is overall a polarization, right? So we're seeing the states that didn't vote for Trump are more energized to try to negate the Trump agenda. And the states that did vote for Trump are ready just to let things slide. So there's opportunities for state legislation in certain states, but I'm not optimistic about that around here. Lawsuits against the government. I think Pat's got quite a bit of focus on this, but there's both scope for complaints, under the APA of arbitrary and capricious action, and also many environmental statutes contain duties that the government has to fulfill, and we've done a lawsuit around one of those duties. But I think there are a lot of affirmative duties that the government has to fulfill. They already had a hard time keeping up with those affirmative duties under the prior administration, so the chances of them keeping up with those affirmative duties under this administration are pretty small. And finally, I want to touch on something close to my heart, which is lawsuits against polluters. I think that those are paramount in terms of we're seeing EPA enforcement going down, and I think we're seeing basically a whole lot of stuff flying at us, and it's hard to keep up capacity, but I think that lawsuits against polluters also provide a very good mechanism to both make some direct difference, but also to tell some compelling stories about how real people, real Trump voters, are affected by pollution. So, and then to go back to the title, not exclusive, right? What we found is if you're running any one mode of action, generally you're not going to do very well. Ideally, you want to try to put together as many modes of action as you can so that they're synergistic. And in particular, what we found is that if you don't have people power, then your detailed comments are not going to make a big difference. But if you have people power, then your detailed comments can make a big difference.
Richard, on that subject, your relationships with the bureaucrats, if you will.
Right.
There's some good bureaucrats.
Absolutely.
How important is that in trying to, get some things going at the state level or even federal regulatory level?
I mean, I think you've got to be a little careful, right? I mean, I think normally we sort of rely on, we do obviously we do have some dialogue, informal dialogue with bureaucrats, but in general we rely on the fact that those bureaucrats, they don't, somebody didn't join the EPA 10 years ago because they hated the environment.
Right.
Right. So normally when they're being told from the top, don't do your job, that's generating a certain amount of resentment. And so they're looking for opportunities. So let me just pull up one that we've been working on quite a bit. This is a long battle that Riverkeeper's been involved in about PCBs in the Hudson. GE released a massive amount of PCBs in the 50s and the 70s. It's been hanging around for a long time. EPA, under the Obama administration, did order them to do some dredging, which they did. But that hasn't actually resulted in the cleanup expected. So we've been pushing for more cleanup. And the EPA, even under Obama, actually, the EPA was about to sign off, saying the cleanup was adequate. So you can imagine that when Trump won, we weren't that optimistic about this fight. But actually, we found, a couple of things. One is that, again, because the PCBs lead to health effects, right? There's fish advisories all up and down. Do not eat for most of the Hudson. And again, fishing is something that's close to a lot of people's hearts. They really want to be able to eat the fish, and they want to have that feeling that they've got clean water around them. And it's not an elitist thing. Fishing, in fact, is quite a non-elitist thing. So it's an appeal that is pretty broad. It's a complicated issue, so obviously whenever you're in a complicated issue, the first thing to do, frame the issue, try to figure out what you can say that will really energize people. And one thing we found in this case that really energizes people is say, well, there's all this focus on the upper part of the river, but there was never any focus on the lower part of the river. And it ended up that the lower part of the river, where most of the people live, has no targets for cleanup. There's not even an investigation going on. And people go, wow, I can't believe that. 50 years later, there's not even an investigation. And that leads people to think, yeah, maybe EPA is not doing a great job here. So then we need to get the word out, right? And, you know, all the usual things apply, right? Get the word out. You have to have a hashtag. We came out Healthy Hudson. You have to have social media. You have to have a campaign colour. I mean, it's surprising what a difference it makes just having everybody in the room dressed in your colours, right? And, you know, unions do this all the time. You know, our opponents do this all the time. We used to do it all the time too. And I think somewhere along the line, I don't know, we maybe forgot how to do this, or we forgot how powerful it is to have people all come together wearing a similar colour and really take control of a room from the agency. We had rallies. Here's me standing outside with some nice signage. We engaged federal and state reps. We actually were able to engage some Republican state reps because, again, this is not really a political, you know, the GE is the bad guy, right? So it's political in the sense GE is the bad guy. But in New York State, a lot of people are prepared, Republicans are prepared to say, yeah, I care about wanting to fish, I care about wanting to go out on the water. And so I care about this issue. And we're not asking for government money being spent here, by the way, we're asking for GE's money to be spent. We were able to get, and this was actually a record number of public comments on this 5-year review. And what we've seen is, and we were able to get hundreds of citizens engaged, so we showed the agency, this is a popular issue. By the way, we did some science too. I don't know if I had that. Yeah, we did some science. Which showed that EPA's document, I was quoted somewhere as that EPA's report isn't bad science, it's actually magical thinking. You know, because they basically wrote the whole thing from the back end. You know, they said, we know the result, so now how do we move from the result to the report? So I won't bog you down in the details here, but bottom line is we work the inside track, and what we've seen is a lot of movement from EPA. They're starting to say, yeah, lower Hudson, you're right, we should maybe do something about that. They're starting to say, yeah, well, you know, the state has come out against us, all the trustees have come out against us, maybe we don't want to be entirely isolated. So we have been able to get some movement from the Trump EPA that actually we couldn't get from the Obama EPA, which is kind of interesting. Next one, anchorages. This is about an advanced notice of rulemaking from the Coast Guard, which is about trying to enable more oil to move down the Hudson. So it's about enabling more oil barges to come up and down the Hudson, and obviously that has risk of spills, so forth. And you know, in New York State, there are lots of very energized people around the issue of climate change, and they're looking for action. And so this gave them kind of an action point. And so here we managed to get 10,000 comments submitted, various municipal resolutions. We got state legislation passed, we got federal reps engaged, and ultimately the Coast Guard backed away from the proposal. So once again, you know, it's not easy to get the Trump administration to move, but they are movable. Lawsuits against the government. We have a nice lawsuit entitled Riverkeeper versus Pruitt. What happened is that New York State revised its water quality standards. EPA reviewed them, said they were scientifically indefensible, but didn't order any changes. So we said, well, actually in the Clean Water Act, there's a mandatory duty to review, and where they are inconsistent with the Clean Water Act, you have to order improvements. And so EPA basically came along and said, well, if you give us a stay, Judge, we'll fix it. So they kind of acknowledged that we had a point. And I have to say, the DOJ lawyers didn't seem particularly motivated, it has to be said. I mean, I sort of detected in the DOJ somewhat less zeal than normal perhaps because they were like, this is not an easy case, but they can't settle it, right? That's one thing that's changed, is that they're not allowed to settle it. So they're sort of forced to go through the motions, so their approach was, let's just get a stay and we'll fix it. We managed to break through the stay. The judge denied the stay in the end, and as soon as the judge denied the stay, a week later, EPA issued the determination that we wanted, and that actually happened on Friday. So that was quite nice, although, of course, it does mean that we're facing problems of mootness, and the chance of our law firm getting fees is probably pretty small.
Richard, in that case, you had Judge Broderick, who was an Obama appointee.
Right.
How much did that make a difference in y'all's litigation strategy?
Well, Rob, if we could only choose the judge before we filed the litigation, it would have made a big difference. But no, it didn't really make any difference. Basically, we felt like this was a winning case. And, to tell you a little story, the EPA asked us to come for a meeting with them before we filed the case and said, why don't you delay filing the case? And we said, well, why don't you tell us why we should delay filing the case? They're like, well, we can't tell you why, but believe us, it would be a good thing to delay filing the case. And there was like 10 people on the phone from DC, And eventually we kind of went around in circles saying, well, there must be a reason why you want to have this meeting, right? This is why we came here. Oh, well, we thought you wanted the meeting, So we had this sort of bizarre sort of Monty Python-esque discussion. And in the end, the EPA person said, listen, I think what you should know is that we're your friends here. And the people in DC are not your friends. So if you file this lawsuit, it's going to go under the supervision of the people in DC. So that was kind of interesting, although it turned out we went ahead and filed anyway, because we were kind of, that was too much palace intrigue for my taste. So we went ahead and filed anyway, and we got a pretty good judge, and we made some pretty good progress. So, but I think those are the signals that you're hearing. Finally, I just wanted to highlight a lawsuit against polluters that I do actually while I was at Public Justice. This was a lawsuit about earthquakes in Oklahoma. And so the injection of fracking and other oil and gas production waste deep down above the bedrock was causing bedrock fractures to open up, and then that was causing a massive increase in the amount of earthquakes. We filed what the industry, I think, thought they were disparaging us by calling it the Star Trek of lawsuits, right? They said that we'd boldly gone where no man had gone before with this lawsuit, because it was a RCRA case, but it wasn't about contamination, right? And they said, well, RCRA is all about contamination. They moved to dismiss, but before they moved to dismiss, they actually got a law passed in the Oklahoma legislature that allowed the state regulators to regulate the injection to control earthquakes. Their position before the lawsuit had been that actually under the Safe Drinking Water Act, the only reason that the state can control injection is to protect drinking water. And their argument was, well, we're so deep down in the ground, there's no way we're getting into drinking water, so basically, you just have to give us a permit for whatever volume we want. And a couple of weeks after we filed the lawsuit, and a couple of weeks before they filed their motion to dismiss, this law got passed through the Oklahoma state legislature, which, if you know anything about Oklahoma, normally things don't happen there without the oil companies saying it's okay. And it allowed the state to control injection, which they were doing, and the judge basically waited a year and saw that the number of earthquakes were coming down, and ultimately dismissed us without prejudice on the basis of birth and abstention primary jurisdiction. And at the time, of course, because I'm a litigator, I was annoyed. I'm like, this is ridiculous, blah, blah, blah. But now I've switched hats a little bit and become a legal director of Riverkeeper. I realized that we could have never got a state law passed allowing control of earthquakes in Oklahoma. So this wasn't the result that we intended, but it certainly was a lot better than no result at all. So that's my first little bit, and I'll pass it on to Pat, I think, right?
Thank you, Richard. So I am going to talk about suing Trump and Pruitt and Zinke and Perry, not necessarily in that order. But the first thing I want to say is the most important thing about where we are today is what's going to happen in November. So the midterm elections are everything. They've never been more important. The outcome has never been more weighty. If we see at least the flip of the House of Representatives, I think we can honestly say that we will break the trajectory that we're currently on. I don't know exactly where that's going to take us and what that's going to mean, but there simply is nothing more important than what happens in November to the future of, I don't know, the democracy and the environment. The other thing I'll say to the young people in this room is you need to get off your ass and run for office, okay? I'm talking to you. I'm talking to you. I'm too old and too cranky. We get the government we deserve. We get the government we deserve. So the second most important thing is for more and more people to get involved in politics and get involved in running for office. I don't care what level of office you're talking about. Get involved, get elected, make a difference. You can. You will. I'll be dead, but you can do it. You can do it. Okay. So I did a paper. I don't know if it's posted or not. Maybe you can track it down.
It should be on the website.
Should be somewhere. I couldn't find it, but somewhere.
It's the AG.
So there's a couple things. Some resources for you. There is a link to a site that collects all of the lawsuits that have been filed by the state attorney generals across the country. It's 115 county. 115 county against the Trump administration. You know, when Pruitt came to office, he said his two guiding principles, his North Star, what were they? Federalism? Yeah? Rule of law. Right? Okay. So federalism, I think, means red federalism, because what we're talking about are the blue state AGs and 150 lawsuits in county. And they're going to keep going. Another website you're going to want to know about is the Sabin Center at Columbia University. That tracks all of the deregulatory actions, every single one of them in detail, tracks all of the lawsuits that are being brought, not just by the AGs, but by everybody, not just here, but all over the world. So there's some real resources out there. Look, we've been dealt a tough hand, right? But there's no whining about this. Got to play it out. Got to play it out. So let me say a few things about how some of the litigation against the government is going. EPA just put out this report. No surprise, crowing, we're repealing everything. We're winning everything. We're getting so sick of winning we can't hardly stand it anymore. Right? Well, they're not actually winning. They're not winning. They're signing lots of orders. They're crossing out lots of guidance. They're threatening to do this, and in the process of doing that, they're not winning in court.
But they're appointing judges.
They're appointing judges. Thank you very much. That's a product of electoral politics as well. Does it matter? Does the Supreme Court matter? I don't know. Maybe.
All those district court and appellate courts.
Yep, I hear you. They're going to appoint more than probably the last 5 presidents combined. I understand. I got it. Tough hand, you know. Wish it weren't true. It is. So, here's the thing. A lot of the mistakes that the Trump administration are making, most of the law students in this room would flunk out of Tulane Law School with the kind of legal work they're doing. So, let me tick them off. They start off with methane, you know. Is methane a problem? I don't know. Do you care about the climate? Methane, 87 times more potent than carbon dioxide over a 20-year period of time. Does 20 years matter? I don't know. Does Greenland matter? Does the Arctic matter? Yeah, I think so. So, right out of the box, Pruitt says, well, we're just going to suspend the first ever methane rules for the oil and gas industry. That's the largest source of methane outside of livestock in the world. And do we have any idea of how much methane is coming out of a natural gas system? What do you think? Within an order of magnitude, do we? Of course not. Of course not. No idea. In fact, it's probably so high that gas is much worse than coal. That's what most of the data that's been gathered. Anecdotal, top-down, bottom-up, wellhead, atmosphere, wherever you look, methane, methane, methane. Okay? So that's the first rule targeted. One of the very first rules targeted. And so Pruitt says, you know what? I'm just going to suspend it. Why? Because the industry's petitioned for reconsideration. Oh, neat trick. What did the industry say in their petition for reconsideration? You didn't pay any attention to our comments. You didn't give us an adequate opportunity to give you comments. You didn't respond in kind to our comments. So the court looks at the record. You see, there are administrative records. Remember? We haven't lost that. There's still administrative records. There's still shit written down that you can find. And you can look up. You can look it up. So the court did. It looked it up and it went, no, wait a minute. They did respond. No, wait, they did respond. No, they did respond. And no, you didn't raise that. And So the court, very carefully, D.C. Circuit, in the quiet confines of their chambers, went through the administrative record and said, Mr. Pruitt, you're not wearing any pants. Okay? So, no, you don't have any rationale for suspending, extending, delaying, kicking the can down the road. No. So you might think, okay, Pruitt should get smart and find some other friends of his lawyers in the oil and gas industry to help him the next time. He doesn't. Because the next move is from Zinke. So they're not talking, apparently. So Zinke says, you know what we're going to do for methane? We're going to repeal the BLM rule on fracking, which requires that you stop flaring and plug the leaks and reduce the amount of methane that's coming off federal lands from oil and gas operations. They do it again. Same thing. We're going to suspend the effective date. Okay, rule of law, right? What does the APA say? Section 705. You cannot extend the effective date of a rule that's already in effect. So that's reversed. 2 times, state of California, 2 cases, twice the Trump administration, through BLM, Department of Interior, tried to punt the methane rule. Didn't work. Another one. We know the Trump administration's view on climate. And by the way, the president said, well, we're getting out of Paris. Well, no, we're not actually getting out of Paris. Did you know that? We're not getting out of Paris. And here's why. Victor can tell you. No, but the short version is simply this. First of all, you can't announce you're getting out of this agreement, this Paris Agreement, the Accord, for 3 years. Now, you saw the Rose Garden ceremony. You saw the brass band, right? Probably some of you. And you thought, oh, hell, I guess we're out of Paris. No, we're not. No, we're not. That's no more than a tweet. That's nothing. Zippo. So 3 years is when the United States can announce formally and file the paperwork to withdraw. Then they have to wait a year. So when you do the math, you know what the 4-year time period would be for getting out of the Paris Accord? 1 day after the November election in 2020. So we're not getting out of Paris. Okay? Don't be taken in by all this crap. How many of you watching Fox News? You've got to vary your media. But he did, Trump administration certainly did repeal the CEQ guidance. In fact, they abolished CEQ. Council on Environmental Quality. They repealed the CEQ guidance on you have to consider climate effects of federal activities. Oil and gas, coal, offshore, onshore, whatever. Coal trains, pipelines. So they abolished that, right? Takes care of that. Not so fast. Not so fast. The courts are still ruling, one after another, coal leases, coal trains, pipelines. You do have a duty to consider downstream greenhouse gas effects. You have to do that, the best job of quantifying them you can. And by the way, yeah, you still have to consider the social cost of carbon. Whether or not there is a guideline or a workshop or a piece of paper that says you have to consider the social cost of carbon, it only makes sense to do so. See, that's the thing about courts. Even Republican courts, sometimes, not always, sometimes, they still look at facts, they still look at logic, they still look at law, they still think these things through, they still require explanations that your Aunt Mary could understand, and that's our job. All of that, presenting that. Factual, objective, credible, honest, solid, legal work. That's our job. And when we do it, we win. Sometimes. There's no guarantees. Don't think you're going to win every time. You're not losing, you're not trying hard. So, pipelines. These are big issues. These are definitely headed for the Supreme Court. FERC takes the position, Federal Energy Regulatory Commission, licenses gas pipelines. Hey, we're not burning the gas, we're just moving it. So we're not the legal cause of all this stuff going into the atmosphere. We've got nothing to do with that. And when we put it on a boat, which we will do soon, and an LNG and send it someplace else to be burned, we have nothing to do with that either. There's some interesting legal questions there as to where does the responsibility lie for taking account of those kinds of downstream effects of gases. So far, D.C. Circuit is split on this question. So this one looks like it's teed up at some point for the High Court, who's ever there. But here's another case that you've got to pay attention to, and you've heard about it. Our Children's Trust, the kids case. Juliana versus the United States. Pending in the District of Oregon before Judge Aiken, Ann Aiken. Now there's a woman with true grit. Unafraid. Recognizes the historic moment facing the United States and the courts and the government and the people. And Judge Aiken has said, let's have a trial on what the administration is doing, the United States government is doing, writ large, the whole United States government and all of its manifestations. Let's have a trial. And you can call your first witness. If you think climate change isn't happening, let's hear it. And why? Or if you do think it's happening, but humans aren't responsible, let's have a trial. You want to have a red team, blue team debate, Mr. Pruitt? We're going to give it to you. We're going to give it. See how many scientists you can get to come. That's up to you. Okay? You want a trial? You're going to get a trial. And then the other thing is, so what exactly is it you are doing or are not doing, and why? Because Judge Aiken says there's at least a colorable claim. Here's a radical idea for you. That we have a right, constitutional-based right, Fifth Amendment right, substantive due process right, to be able to live, I don't know, in a world that isn't falling apart, with a safe climate, a stable climate. And that the children who are bringing this lawsuit have almost nothing to say about that. They will get what we give them, period. You're not going to put the toothpaste back in the tube or unring the bell. Whatever's happening right now is with the future generations for the foreseeable future, i.e. forever. So if any of this stuff is real, if there's a real risk, if the consequences are really serious, now is the time to do something about it. The Ninth Circuit has just denied the government's latest move to try to get a writ of mandamus to kill the trial and dismiss the case out of hand. And the Ninth Circuit panel, by Chief Judge Thomas, has just issued its opinion. It's not, 100% victory, but it is a victory to the extent that there will be a trial. The government is probably going to continue to try to stop the trial by arguing standing and other justiciability issues. But it looks as if there's going to be a trial. And what a trial that's going to be. So my suggestion is book your flights to Eugene soon. You don't want to miss this. This is the Scopes trial of the 21st century. Very cool. Very cool. What else? What's coming down the pipe? How much time? I'm not doing.
You got plenty of time.
Don't ever tell me I got
No,
plenty.
I'll also tell you to stop. You got plenty of
That's
time.
your challenge. So, coming down the pike, Clean Power Plant. Heard a lot about that, right? Here's the thing. We are within 4% of accomplishing the Clean Power Plan. You may remember when Obama administration, Gina McCarthy, God bless her soul, fought her way through and got the Clean Power Plan finally adopted. The goal was 32% reduction from 2005 levels by 2030. We're within 4% already. So it was a tiny, modest little goal to begin with. And so what I'm about to say about the litigation is almost academic, because the truth is, and Victor could tell you a lot more about this, the energy transformation is happening. Not nearly fast enough to keep up with the science. No. Way short. But it's happening. It's exciting. It's moving. I don't care what Trump says. Coal's not coming back. Sorry. No, I'm happy. So But there is this legal question. Since we're a law school, let's talk about it. The case was fully briefed and argued. It was the longest oral argument in the history of the D.C. Circuit, 8 hours. And it was submitted. The argument, by all accounts, even by people like Tom Lawrenson, who I greatly respect, who represents the industry point of view on this stuff, seemed to go EPA's way. It was a good day for EPA. Good day for EPA on all the issues. And there are a lot of them. But then there was the election. So on this one, you got to give this, the points to the Trump administration, because this, for whatever reason they have succeeded. This, by the way, the argument before the D Circuit was the whole panel en banc. Minus that guy Garland, who was in line for a promotion that didn't come through. Remember that? Anyway, 10 of them. And so the Trump administration, Pruitt, ran to the D.C. Circuit and said, "Hey, let's call time out on this case. We don't need a decision from you." Even though, of course, Mr. Pruitt said the whole thing is crazy, unconstitutional. This guy, Lawrence Tribe, you ever heard of him? Lawrence Tribe, something like that? Harvard professor. He said it was unconstitutional and crazy. He said, he said his former pupil Obama just obviously didn't take his course, didn't pay attention, because this plan was totally dead on arrival. But, says Mr. Pruitt, we believe it is totally unconstitutional and illegal, but we don't really want your opinion about that. We don't really need you to tell us that. What we'd rather do is say, we're thinking about replacing. So the old repeal and replace trick. Well, we've been in the repeal and replace mode now for 13, 14 months. And the D.C. Circuit keeps going along with this. And every 30 days, EPA files a new report. Full disclosure, we file an amicus brief in the case. So we get all these reports. And each time they say, well, we're getting closer to actually announcing what we're thinking about doing at some point, sometime. And the court just keeps going along with that. But at some point, you can run, but you can't. You can run, but you can't hide. At some point, Pruitt's going to actually have to bite the bullet, and so is Trump. And here's the thing: Murray in the coal industry and others in the fossil fuel industry are pressing very hard for Pruitt to make the following announcement: we hereby repeal the Clean Power Plan, and we ain't doing nothing. Well, you see, that's a problem. Because in Mass versus EPA, the Supreme Court said, if you make the endangerment finding that's required under the Clean Air Act, then you must regulate carbon. Period. No ifs, ands, or buts. And Pruitt is very reluctant, although people are pushing him, to repeal the endangerment finding. So he's in a box.
Now explain the endangerment finding.
So the endangerment finding basically says, does carbon dioxide and the other greenhouse gases pose a reasonable likelihood of a threat to public health and the environment? And there's another kind of finding you have to make, that certain sources are also contributors to that. So there's two sets of these endangerment findings and cause or contribute findings that have to be made. And they've all been made, and there's an enormous record. And if anything, the science since those findings were made is even more overwhelming today. So here's the point. If Pruitt falls for the gambit of saying we're not doing anything about carbon pollution from power plants, it's almost impossible to see how that could be defensible in court. He's more likely to do what the smart money is telling him to do, which is come up with a new rule that applies within the fence line of the facilities, because this design of the Clean Power Plan, the genius of the Clean Power Plan, was to take advantage of what's happening already in the energy sector and capitalize on efficiency. It wasn't formally part of the plan, but it's happening. Efficiency, renewables, and dispatch gas, higher in the order of dispatch. Usually the dispatch is lowest cost. The Clean Power Plan would advance the dispatch of gas over coal from the natural dispatch order. And all of the RTOs in the country, the people that run the grid, said, we can do this, it'll be fine, there's no reliability problem, don't worry about it, let's go forward. So the legal argument, though, because this is a very sort of underused provision of the Clean Air Act 111D, the legal argument is that should really only apply to facility-specific things, which would mean you increase the efficiency of the way the plants operate, and that would get you maybe 6% reduction, improvement, maybe, overall. But with this using the integrated grid and deploying low-carbon sources and bringing renewables online, which are coming online all by themselves, you can greatly increase the amount of carbon pollution reduction. So that's the strategy of the Clean Power Plan. Those are the issues that have been fully briefed before the D.C. Circuit. When Pruitt comes up with something to replace that, the question is going to be which administrative record is the court going to look to judge the legitimacy of whatever rule Pruitt comes up with. Now, Pruitt's notice in the Federal Register of what he's thinking about doing on the Clean Power Plan basically says, we don't need a reason to repeal the Clean Power Plan adopted by the Obama administration. We won the election. Full stop. So we don't need detailed reason. We don't have to show a change in facts. We don't have to show a change in circumstances. We don't have to show any flaws, factual, technical flaws. Now, we do maintain that the Obama administration's interpretation of the act was illegal and overreaching. Okay, fine. That's been briefed, fully briefed, on a record. And it's sitting there, waiting for a decision. So here's my prediction. I don't think Pruitt's going to get by with the gambit, we don't need a reason. I don't think that's going to work.
And how long do you think the D.C. Circuit will allow him to keep?
That's a good question. I mean, they seem to have limitless patience. And I keep seeing Sean Donahue's papers being filed and Mike Myers' papers from the New York AG being filed, and I'm looking at the papers and I'm saying, how can the court continue to allow him to get away? This is obviously a stalling tactic. They're running out the clock. It's clear that's what they're doing. But I can't answer your question why they're letting him do it. I don't know. They're letting him do it for now. Sooner or later, maybe not. I don't know. Maybe something will happen and the Trump administration will disappear. Yes.
Does he not want to repeal the endangerment planning because the record is just so...
Oh, it's just so overwhelming. It's almost... I have some inside information about the Giuliani trial. And here's the thing. 3 of the scientists that the Obama administration had talked to, I should, full disclosure, Obama was against the Giuliani case too, right? So they moved to dismiss it. Here's the other kind of cool thing about that, though, now that I think about it. Normally, when you sue the government, it's dial a brief and dial a response, and you get this thing from DOJ, you have a really long, like a 70-page complaint, right? Very detailed, factual, legal, policy, background, structure, posture, all of that, and you get an answer that says something like, we neither admit nor deny anything, or calls for a legal conclusion, or the documents you were talking about speak for themselves. Whatever it is, they don't substantively respond to the answer. Here's the difference. This is what we call putting the turd in the punch bowl. So the Obama administration, DOJ, admitted everything in the answer. All the science. They didn't admit that we're bringing the world to its knees. They didn't admit that we're violating the Constitution. They didn't admit that they weren't doing everything they could possibly conceivably do, because they were, with executive authority and no cooperation from Congress. But they didn't admit anything like that, the legal conclusions, but they admitted all of the facts. So for Pruitt and company to try to extract themselves from the admissions on the record will be something interesting to watch. So that's Giuliani. 2 minutes?
Sure.
Can't quit without talking about the waters of the United States. So here's another one where EPA, after years and years of being beaten up by virtually everybody to try to clarify the mess that the Supreme Court has made of the Clean Water Act geographic jurisdiction, and I mean Rapanos, and I mean Scalia, and I mean Swank, and I mean Rehnquist, naming names. I mean judges who have no business whatsoever mucking around in stuff they don't understand and are better left alone. So the Supreme Court has made a mess of the Clean Water Act. The scope of jurisdiction, what's the definition of waters of the United States, what's the inlet, what's out, what's a tributary, what's a wetland, what's adjacent. All of that stuff is a mess. And everybody's been unhappy, and Congress has refused to do anything about it. So EPA finally bit the bullet and said, all right, we'll do it. Here's a rule. I know you're all going to hate us, but here it is. Some good things, some bad things. Went into effect in August 2015. Was immediately enjoined by the district court in North Dakota. Judge Erickson, who issued that preliminary injunction, has been rewarded with a seat on the 8th Circuit. But his preliminary injunction only covered the states that sued in North Dakota, that's 17, and so the rule was in effect in the other 23. And, I don't know if I had my math right. And, but meanwhile, the 6th Circuit issued a nationwide stay. So there the 2015 rule sat under a stay. Supreme Court has now ruled that the 6th Circuit had no jurisdiction, that these cases challenging the Clean Water Rule, which is what EPA calls it, or WOTUS, which is what the opponents call it, and all those challenges to whatever rule it is interpreting the waters of the U.S., they all have to be litigated in district courts, and you might say, which district court? And the answer is pick one. So here's the thing. The 6th Circuit has now lifted the stay because of the Supreme Court's decision saying that they don't have jurisdiction. So the 2015 rule should be in effect in all those states except the ones under the injunction in North Dakota. But here comes Mr. Pruitt again. This time, he's come up with some new terminology that we've never seen before. So now we're not talking about suspending the effective date of the 2015 rule, which went into effect in August. We've tried that 3 times and lost, so we're going to change the applicability date. Yeah, I've never heard of it either. Nor have people that are really smart about administrative law ever heard of it either. But that's a rule now in the Federal Register, and it says, we hereby declare that the 2015 rule, as soon as the 6th Circuit lifts the stay, will not be applicable until 2020 or 2019. Magical thinking, is that what you said? The New York AG was 1 hour after the notice appeared in the Federal Register, Southern District of New York. Enviros have piled in. Enviro cases in Southern Environmental Law Center has a case in South Carolina. I'm not sure why they picked South Carolina. You guys down that way may be able to tell me why. I think that's a joke. I think the courts are going to strike that down, which creates the following very fascinating situation. The 2015 rule, which everybody has written off as dead, and which the Trump administration has already claimed credit for killing, will actually spring to life shortly. And then we're going to have another case and another argument about the repeal of the 2015. Are you still with me? This is really fascinating stuff, isn't it? Yawn. So the applicability date is one gambit to stall the 2015 rule. The other one is a rule that actually repeals the 2015 rule. And we've been waiting for that rule since the comment period closed in September. Where is it? We don't know. When it comes out, it will be a final agency action subject to challenge in the district courts. We'll query which one, pick one. So you're going to have this is just wonderful stuff for anybody who wants to practice law. This is really the Lawyers Full Employment Act. Honest to God that's an overused term. This one is for real. You're going to have the following kinds of litigation. The preliminary injunction by the district court attempts to impose a nationwide injunction against the 2015 in other courts like Texas. The AG's challenge to the change of the applicability date pending in New York. Then when the rescission rule comes into play, then a whole other series of lawsuits. And then, to cap things off, we'll have the replacement rule, which the president has said he would like one that the late Justice Scalia would really like. And here's my last point. There have been 12 circuit court opinions interpreting the Rapanos case, which is the source of much of this confusion. Scalia wrote the plurality opinion, not the majority, plurality opinion. Stevens wrote the dissenting opinion, 4-4. Kennedy wrote the concurring in the judgment but not in the reasoning or anything else opinion. And saying, what I like is this significant nexus idea, a term that doesn't appear in the statute in the regulations, in the legislative history, in any of the scholarship, anywhere. It sprang full life in Swank. And it was just a reference. Significant nexus. So the test, the point is that every single circuit court that's considered the question of what test under Rapanos applies has said, sometimes it's going to be Kennedy only. Some courts have said Kennedy is the exclusive test. All courts have said Kennedy is the permissible test. No court has said Scalia is the permissible test alone. Some have said it could be either one, and some have said it would be valid under either one. So I'll close by saying we have lots of fascinating litigation to keep us occupied in company until the cavalry arrives and frees the nation from the dead hand of an incompetent, dangerous administration. That's just a political point.
Thank you.
Only have 20 minutes?
You're right. Cool. Okay. You had 20 minutes.
Okay, look, I didn't want to go farther. All right, so anyway, my,
That one won't work. You just have to use the...
okay, my resume was outdated. I don't know, that's the one I used 20 years ago. So I used to be in litigation support after I graduated from here, and then on July 12, 2002, I went to West Virginia, and since then I declared my own little war on coal. Luckily, Obama got the credit for it. My enemies, I made some enemies. They're murdered, in the ground, dead. They're still in jail, and they're running for U.S. Senate right now. All of my enemies. This is from a case last year, in 2016, and it's about coal contamination. I sued gas companies, coal companies, and chemical companies. I got a special hatred for coal companies. This is what coal companies do to people's water, okay? This comes out of the well because slurry has gone down. So we're going to truncate this. These are ice cubes. And the water that comes out looks clear, and then when it freezes, it looks like that. Okay? They destroy the water, there's no question about it. What the? So, and in this case, Belcher versus Dynamic Energy, in a convoluted bunch of facts. The current governor of West Virginia was running. He was a Trump. He was a mini Trump. He switched parties. Was a Democrat, became a Republican. Was a Republican, became a Democrat. Bought a coal mine back from the Russians for $5 million. 4 years earlier, he'd sold the same mine, the one that polluted these people's water, for $500 million, so he made a $495 million profit. Since he was running, pretty good profit on that mine the day he bought it back, he made a deal with the union. Support me for governor, and UMWA, I'll make these new mines I bought back from the Russians, I'll make these mines union. Second day of trial, there's 100 coal miners in their reflective stripes in their UMWA gear sitting in the courtroom. Actually, second day of jury selection. I'm like, Your Honor, we got to go in. Judge says, I'm not going to grant a mistrial. I'm not going to do anything. These people have a right. My brother's running for Supreme Court. All right? So we went through and we got zeroed in the trial. Now, I sue coal companies in coal country, and I've been very successful about that because in West Virginia, we have a history of resistance. My number one juror since 2002 has always been an underground mine foreman. They know the bullshit that goes on, and they know what happens. I'm up in the Supreme Court right now. I'm waiting on a decision. There's somebody to hate. Me. Lots of people hate me. The governor. Everybody hates the governor. The UMWA. 2 out of the 5 members of the Supreme Court hate the UMWA. Of course, there's my clients. 5 out of 5 are going to hate them because they're poor. All right, and then the Russians. Thank God for the Russians. So I got 5 members of the Supreme Court, and I got 5 people to hate. All right? Why did I lose a case like this? Well, typically, you can call it rules of the road, you can call it reptilian, plaintiff's practice, you can call it violating the golden rule, which you should do every time you get in front of a jury. You just don't want to get nailed and mistried for it, okay? And all of those theories say you want to put the juror in the position of the plaintiff. And the reptilian theory is you want to make the juror understand that they and their family are threatened. Well, I lost another trial just a few weeks ago. This was against EQT, a gas company. So, basic rules of the road, basic trial practice, basic trying to use the golden rule, basic reptilian. Did they have a duty? Were there rules to be followed? Heck yeah, there were 2 sets of rules. There was the government rule, and then there was their own internal rules. And they didn't pay any attention to any of them. Did they breach their duty? Well, all those rules say that if you got that you're not allowed to have landslides. So here's the year before this big flood, and here's the year after. No trees, no trees. There was a landslide there. Very simple. Did they breach their duty? Well, you see this pipe? When it was designed, you don't put a gas pipeline down a mountain that's just hanging in the middle of the air. That's a violation of all kinds of rules. It's also proof that there used to be dirt there. Where did it go? It went down the hill. It went down the hill to my client's property. There you go. There you go. You see that shadow there? That's 100 yards down that mountain. That's how much dirt got moved out of there. See there? That's my client's house. That's what happened after the flood came because they didn't follow any of their rules. They didn't have diversion ditches. They didn't have riprap. All the things that could have prevented this. And see all that dirt behind? That's the landslide. Okay? I don't know how you get any clearer than that. All right? You had dirt. You don't have dirt. You clearly had dirt before because you wouldn't hang a gas line out over the middle of a damn ridge. Now, why did I lose this case? I'll tell you why I lost the case, because I represented poor people. If you got one finger and one thumb, you got yourself a map of West Virginia, okay? This part is rich, this part is okay, most of this part's all right, but down here, these are the people that won World War II for you. These are the people that you wouldn't be here today, wouldn't have any cars, because this is where metallurgical coal comes from, right down here. This is where gas is. This is where the poor people live, because poor people live on top of other people's mineral wealth. Anywhere you go in this damn country, anywhere in the world. From Congo to southeast Louisiana to West Virginia, poor people get stuck living on top of rich people's wealth. All right? And when that happens, it don't matter. Now, the poorest part of the poorest state is Mingo County, and I've been practicing in Mingo County since 2002, and Mitchell Branch, where these people live, is the poorest part of that county. The poorest part of the poorest county of the poorest state. If you want to do well in trial, represent rich people, okay? Poor people now are the reason we're where we're at today. In this county, 85% of the people voted for Trump, all right, against all self-interest. The defendants have flipped the reptile. They flipped the rules of the road, and now the golden rule is on their side because they make the jury afraid. They make the jury afraid that if they vote for us, and instead of these shiftless poor people, then they're not going to have any jobs anymore. And very few of them have jobs anymore. And that's one of the problems in Trump's America.
Electric bill will go up, too.
And the electric bill will go up. DEP protects the corporation. This used to be a winning concept. Not anymore. There's a DEP guy. There's one of my clients. This is from the Cedar Creek crowd. That's the water that comes out of her tap every day. People drink this. She doesn't because she's a retired teacher. She has money. Poor people drink that. This guy's staring at it. Says, I don't know. It looks bad to me, but, I don't know. It's certainly not the coal company's fault. Well, today, this argument loses, all right? Because everybody knows that corporations are overregulated, that the DEP isn't, they aren't protecting the corporation. The DEP and the EPA, they're out there killing jobs, okay? So you can't say that anymore. You know, these things, oh my God. I used to be able to say, look, all that red is an exceedance. What they say now in closing arguments are things like, Mr. Thompson relies on a bunch of scientists, but we actually had tool pushers out here, and we had people who work in the mines who tell you they follow the rule. He relies on his science, you know, his yellow and red colors. Well, you know, so I'm not sure what we do about this. This is another thing that I used to file. I'll never file one again. Plaintiff's motion eliminated prohibit counsel from making personalized attacks on counsel. Okay, because that is every time I go in, I am attacked personally. Or on expert witnesses, my experts are a bunch of damn scientists, all right? Or about referring to threats to the business environment or jobs during voir dire and opening or closing statements. Well, you know, I've put that in for years, and I won this trial, okay? People used to pay attention to the judge always grants it because it's so reasonable. You can't attack Kevin, you can't attack his experts, and you can't say you're all going to lose your jobs, okay? Even in today's environment, the judges still grant it, but the judges never enforce it anymore, okay? Because the judges are elected, and they're elected by these people who have been convinced that they're going to lose their jobs and lose their homes. You know, they are losing their jobs. They are losing their homes. It's not my fault. It's not Obama's fault, okay? The reason that they're losing their jobs and they're losing their homes is that there's no more coal left in those seams, that it only takes a few people to run a gas site, and that the people who drill them all come from Louisiana, Oklahoma, and Texas, because that's where you grew up learning how to work on an oil rig. So you don't really want to put a coal miner in charge of an oil rig, or people are going to blow up, all right? So, I don't know, we got a few minutes left, and I know I'm supposed to be the speaker, and y'all are supposed to be the audience, but I got a trial coming up in July against those gas-hogging bastards from EQT. This time I'm lucky. I represent 3 pretty well-off people, actually rich by Mingo County standards. I represent rich people in this case, in the one coming up, so I got an advantage. In my history, when I look at it, when I represent rich people, I got every advantage in the courtroom with the jury and everyone. But when I represent poor people, every strike is against me. So I'm not filing this one. Okay? Next time I go to trial, the one thing I'm going to do is I'm starting right out of the bat. And I'm saying, hey, you've been lied to by these people. Okay? I'm tired of being nice. I've always been very, very magnanimous to my opponents. Bullshit on that. They aren't nice to me, and now they're winning, okay? So the one thing I'm going to do is I'm going to talk about the threats to the business environment and jobs right off the bat in voir dire, in closing statement, in opening statement, in direct, and I'm going to do it in cross. Another thing I'm going to do, as much as I hate it, I think I'm going to pull 90% of the science out of my presentation. All I'm going to say is, this poor rich person, look at their bottle of water. Or in this case, look at this photograph of their nice home being undermined by a landslide from that gas site up on the hill. And I think I'm not going to have any stormwater calculations. All right? What other ideas we have for me? I got a trial in July. I represent people in this horrible place. Help me. What can we do to switch this reptile thing? Anybody got any ideas?
I like those black ice cubes.
Oh, they're tasty, man. It's licorice.
Destroying land value.
Destroying land value, you know, that might work in the next case because I got 3 rich clients. Now in Mitchell Branch, you know, destroying land value is probably a good thing, but yeah, okay, destroying land value. So the reptile thing goes with the only thing we got is our land, and they're destroying the value of the land. All right, got any other ideas?
Got any veterans?
What?
Got any veterans?
Everybody's a veteran in West Virginia. Everybody's a veteran. Yeah.
How does that play?
For your clients who have been veterans, war records, stuff like that?
It all kind of evens out because everybody's a veteran. Like,
Coal company's not a veteran.
you know, but I guarantee you the superintendent will be, who comes to testify. I mean, all my experts are veterans, their experts are veterans. I mean, the veteran thing doesn't really play where everybody is a veteran and everybody... And I tell you another thing that doesn't play is sympathy. Because when you grow up hard, sympathy don't count for nothing. Now, what I have found there for over years is revenge and anger will do it for people who grew up hard. Yes, what do you got?
Well, I'm not sure how much this is worth because I'm not a I'm a science student. So, but maybe pointing out the hypocrisy of the owners of the companies pretending like they give a shit about their workers when really they just want their money, and they act sad about their employees losing their jobs, but they're taking these huge bonuses.
There might be something to work on because, you know, the people are angry. The reason they voted for Trump, remember, these are the same West Virginians who voted for Kennedy, okay? These are the same people who are angry about something, okay? They just don't know who to be angry at.
Kevin, following up on her point, Exxon would always have these commercials. They're all dressed in white lab coats about finding a cure for cancer.
Right.
Exxon.
Yeah.
So, looking at their website, they oftentimes push how clean and how beautiful everything is, and then, you know, what their company culture says on their website is far different than what's happening in the fields.
Okay. Yes.
Where's the defendant, like the corporate headquarters?
Pittsburgh.
Okay.
Oh yeah,
Close
don't
enough,
worry.
close enough.
I throw that in. Out of state, Wall Street.
I have
Wall
a
Street
similar-
bastards.
I have a similar truck coming up.
Protect the mountain ecosystem.
Protect the mountain ecosystem. Well, as long as we take eco out of that, how about protect the mountains? Or the mountain people, you know? Yeah, hey Andy.
Hey, Kevin. There was a report done by a Republican strategist named Frank Luntz, who a lot of people remember from the George W. Bush days, because he helped manufacture the strategy. And he wrote a report pushing green initiatives to Republican states and Republican votes. And very similar, he talked about property rights issues, and then you can talk about jobs in a slightly different way and sort of turn it around, and then you also have your property rights sort of angle, and that those were the things that people in red states most responded to. But I'm going to send you that.
Yeah.
But it made me think that the phrase property rights also goes.
Property, not people.
Not making any more property.
I'm not making any more property.
What about acid rain? How does that work?
Well, that's one of our primary exports in West Virginia. Now, our whole economy is based on that. As a matter of fact, we'll send you the raw materials. You can make your own. We got trains we can send out. Yes, sir.
Were there any guns damaged? Maybe that could help you.
Guns, yeah. He lost his guns. Right, there we go.
Can I just pick up quickly
Yes.
on Andy's point? Because I think one thing I was going to mention but cut, but might be a good point right now, is the stuff about pipelines, gas pipelines, oil and gas pipelines coming through property. It's been a big issue down in Louisiana, and it's been a big issue in New York. It's been a big issue everywhere. And the one thing that has been, one of the things that's been a really useful hook is the power of eminent domain, right? And what happens is that the pipeline company is actually given by FERC the right to seize people's property very early in the process, and it's very hard to contest. And that really annoys people. And it's amazing how, you know, when it's in favor of the oil and gas industry, the conservatives love to ride roughshod over the state's right to determine how its environment is protected. And people actually don't like that. And actually, there was recently a decision on the Bayou Bridge case in Louisiana, where for the first time they got a stay of a federal pipeline or a gas, I think it's an oil pipeline, because it went through sensitive areas, and because it was on appeal, the judge actually issued a stay. That was the first time ever. We actually lost a similar case where we didn't get a stay in New York, and then our response was actually, kind of back to what I was talking about, which is our response was to go up the next day with Facebook Live and show them chopping down the trees to try to make sure that they got the pipeline built before the merits decision came down. So there are some really good hooks around property rights and state self-determination.
Kevin, Board.
I'm sorry. Do you have an economic at all here with, or just an economic contrast of what these coal companies are making and what these future plaintiffs are making? What these people, or are they just so hooked to the job, didn't give a damn?
They're just hooked into the job. They don't give a damn. Gas, because I had a case where a gas company wiped an African American graveyard from the face of the earth, and they actually called into question that those coal miners who have been buried in a company store had a right to be there. And the gas company said, well, they're trespassers to begin with. They had no right to be buried there.
It's a victim of a new way.
Right. And then, so in that case, I got a punitive damage instruction. Once I got the punitive damage instruction, I was able to put in, and I did very well. I got a plaque from your guys, actually, at Public Justice out of that one, and then collected a fee, which was even better than the plaque, I tell you what. Yeah, but I think if you can get the judge to give you a punitive damage instruction, then absolutely, I think you can do that. But of course, Now, gas companies aren't as powerful as coal companies there, or anywhere where they happen to be, because the gas company doesn't employ 3,000 people. Gas company employs 30 people to do, to produce the BTUs of 50,000 miners or whatever, But if you get a punitive damage instruction, that's what we got to do. We got to piss them off, And they also get mad. I was pretty shocked at how much money, these mid-level executives are making. Their corporate rep was making like $220, and but of course it didn't help in the trial. But I was representing poor people again, the very poorest of the poor.
Do you focus just on taking cases with land issues, or do you ever take cases where former workers are now ill and can't work? And
Oh, yeah, we do all of those, personal injuries, medical monitorings, because the coal ends up, there's always a personal injury focus, except in the case of a flood case, there's usually not. But,
On punitives, do you have evidence of deceit and fraud and the same sorts of things they had in tobacco and the same sorts of things they're talking about with Exxon and others?
It's willful, reckless.
Willful.
Reckless and willful are generally my hooks
Yeah.
on punitives, reckless.
What's willful and reckless? I know the term. I just, in your particular case with coal, willful and reckless, if that allows you to go for punitives, you have allegations of willful reckless.
Right, so let's talk about the flood case, okay? It's reckless if your corporate standards and your government regulations require you have diversion ditches and riprap, okay? And then there's something called water bars. If they require you to have them, and you put the site in and you don't have any of those, then the judge found in the gas case that was reckless behavior. So usually it's reckless. And when willful is they made a decision because they designed it. And
recklessness alone is a sufficient basis for punitives?
Yeah, willful, reckless, wanton behavior.
Okay, do all three required, or are they different words?
Like it's always like an or. And with malice. So it's willful, reckless, wanton, or with malice. So so there's an or.
Yeah.
So you can get them on reckless.
I'm thinking of the oil and gas canals in Louisiana, which are easily in excess of their permits, okay?
Right.
So would that give rise to punitives?
Yeah, I think it would be. Yeah, I think that's the basis of the Gruffer decision. $1 billion slam dunk against Exxon was the fact that they just recklessly ignored their duties to monitor their radioactive waste.
Rod, was that?
Well,
that case?
he got to go back to 1980s in Gresham.
Right.
It's a great thought, and whether, it's the storage, handling, and then we had a decision that had to cause injury for there to be a 2315.3 punitive, allegations. You had to have some injury. The canals don't call personal injury. In Greffer, he had personal injury.
Okay, so.
No. Oh, we represented the landowner. Or
Okay.
Stewart did. So I think it was reckless. It was a long time ago. But let me breach somebody else's attorney-client privilege. Okay? Someone told me a story, so I'm not held by this, but they were representing Governor Foster.
That's right.
They were representing Governor Foster in the mediation.
This person.
What?
We know this.
Right.
Okay, he's already done it.
He's on. Well, I don't owe duty because I had no attorney-client privilege. So anyway.
If you need to go to another panel, we don't want to get in trouble. We're past our time here, but this is our personal question and answer.
The governor of Louisiana, in a mediation on his legacy case where he was the plaintiff, said, well, what about punitive damages? And the lawyer got to tell the governor, well, Governor, when you were running this state, you sponsored legislation to take punitive damages away. And he says, oh, no. That was only for frivolous suits, not for this
Not for
one.
mine.
Not for mine.
Y'all been a great audience.